Hello. We hope that you are keeping well in your respective houses. So you might have heard that the stay on possession proceedings is coming to an end on the 20th of September, unless of course there are any last minute announcements to the contrary, which generally tend to happen at 10 to 5 on a Friday evening. So we've put together an article which is going on our website, but seeing as you might be missing some human contact, we thought we'd share our beaming faces with you, and Sarah, Charlotte and I are going to give you a quick rundown of what to expect. So Charlotte, Monday morning comes around, how do we go about cracking on with possession cases?
Well, chums, this is what we do. Claims are stayed at the moment until the 20th of September, but from the 21st of September, we can run amok in the court. But what we need to do is file and serve what are known as reactivation notices. So the court is not of its own volition going to start things off again. The court needs to know from the claimants, defendants, whether or not they want their cases to continue. So a reactivation notice is what's required. The government has helpfully produced a pro forma, which is fine to a point. Unfortunately, it doesn't actually mirror what is said in the practice direction. So in the practice direction, there is no required form. You may want to sit, well, you don't, you won't want to sit listening to, looking at the practice direction 55 as you fill in your reactivation form, but you should probably familiarise yourself with actually what's required. So in short, what you need to do is say whether or not you want your claim to be listed, relisted, or heard or referred to a judge. That's what's required. If you have directions that were taking place prior to the 20th of December, not even December, 20th of September, I'll repeat that, 20th of September, then you need to send a copy of those directions together with details as to new dates in those directions. You can send a draft order of your proposed directions, or a statement that no directions are required and a hearing that's about to happen can go ahead. But with a hearing that's listed, you need to be sending a reactivation notice in order for that hearing to actually go ahead. And this reactivation notice needs to be sent 42 days ahead of the hearing itself. That was supposed to be brief. The reactivation notices can be a little bit complicated, so please take care with what you are putting in them. Sarah can tell you about the rest of the new rules that are kicking in on Monday. Sarah.
Thanks. So once we get into court, your reactivation notice, if it's required, has been served. Then what happens next? And the Master of the Rolls has had a working group, and that working group has set out some detail of basically a new system for dealing with possession cases in the court. So what will happen is this: once a case is active again, so it's no longer stayed, at any point, any party or the court itself can COVID-19 mark that file. And that will happen in certain circumstances. So if the claimant is in difficulty as a result of the pandemic, then the file can be marked, and it can be marked to assist with settlement, listing, case management, and to provide certain information. And in order to do that, certain information needs to be provided to the court. So far as hearings are concerned, the first thing that will happen is that a review hearing will be fixed, and the court will deal with priority cases first, and the cases that will have priority will be those that involve antisocial behaviour, extreme rent arrears, some trespass cases, cases where there's domestic violence, cases that are based on fraud or deception, unlawful subletting, abandonment or death of the tenant, temporary accommodation, and subject to all of those cases that were issued before March 2020. The court will send out a date for a review hearing. 14 days before then, the claimant has to file with the court and serve on the defendant a bundle of documents. and the review hearing will be listed. That in effect is a paper hearing in front of the judge, but on the review hearing day, the defendant will be able to get advice from the duty solicitor scheme. The claimant should be available to speak to the duty solicitor to see whether or not an agreement can be reached. If an agreement can't be reached, but the parties think that the case is suitable for mediation, there is going to be a new mediation pilot running, so the case can be referred to that. And at the end of the day, when the judge comes to look at it, he can make an appropriate order if the matter has been concluded, refer it off to mediation, or if the case isn't resolved at that point, it can then be listed for a substantive hearing, which will be at least 28 days after the review hearing. That will be an attended hearing, so it'll be more like the return hearings that we're used to, but it can be remotely attended. So it may be entirely in person, it may be on telephone, video link, or a combination of those. Again, the defendant will be able to get free advice from the duty solicitor scheme. The substantive hearings, they won't be block listed, so there'll be no block listing like we've been used to in the past to accommodate social distancing requirements. Each case will have a 15-minute slot. There'll be a gap between cases so that COVID measures can be carried out. And if the matter can be disposed of at that hearing, it will do. Otherwise, directions can be made in the usual way to get a matter ready for trial. Accelerated possession claims will still be dealt with in the usual way on paper. The intention is that they will be dealt with in slots that become available because cases settling before the substantive hearing. So if spaces become available, then the intention is that the court use those time slots to deal with accelerated possession cases. So it's going to be a whole new system. Courts will be listing cases up to 3 months ahead. So it may be at the moment you don't get a hearing date immediately. So you don't expect when a case is issued that you will automatically get a hearing date through, and it certainly won't be within the 8 weeks that the practice direction requires. That requirement has been suspended. And it won't necessarily be at the court that you're expecting. Only court centres that are able to accommodate social distancing are going to be used. So just keep an eye on the orders that are coming through to check where your case will be, when it will be, and don't panic if you don't get a date through immediately. It's a whole new system to get used to. We will have to see how it goes, but as ever, if you need any help, advice or assistance in connection with proceedings that have been issued, then we're here and we're going to be more than happy to help with that. So once you have finally got a possession order, what happens then, Rachel?
Yep, so you've got your order, and assuming the tenant fails to leave, then you'll need to apply for a warrant of possession. Enforcement of the warrant can then be carried out by a County Court bailiff, or you can transfer proceedings to the High Court for enforcement by a High Court enforcement officer. Enforcement through the High Court is more expensive, but it was usually the quicker and arguably more effective method of enforcement. So the overall arrangement states that applications will be considered on their own merit, but are unlikely to be high priority at present. So transferring your proceedings to the High Court for enforcement may not necessarily be appropriate, and there's going to be a huge backlog for courts to process. In any event, it might not be the quicker or more effective route now due to changes to CPR Part 83. So from the 23rd of August this year, High Court enforcement officers now have to serve a notice of eviction, giving at least 14 days notice before enforcement of a warrant can take place. So that now brings them in line with the process for County Court bailiffs. So in terms of the actual eviction, the emphasis is going to be on safety of the occupiers and the bailiffs or the enforcement agent. The overall arrangements state that bailiffs and enforcement agents will need to properly explain safety procedures and policies to the occupiers and defendants. So it might be that we see some additional COVID-19 related information being supplied with the notice of eviction, or that uniform policies are put in place, but at present we just don't have that information. The Ministry of Housing has announced that guidance will be issued to bailiffs and enforcement agents, and that there will be no enforcement of possession orders where local lockdown measures are in place. So that will be something to keep an eye on as the pandemic sort of changes in local areas. Interestingly, the overall arrangements have said that there will be no enforcement of possession orders over the Christmas period. We've discussed this internally, and in our experience, enforcement doesn't tend to take place over Christmas, but it remains to be seen when the landlord-tenant truce on possession matters will kick in and how long that will last for over the Christmas period. So unfortunately, it's about as clear as mud at the moment, but we expect further information and guidance to be released sort of in the near future. Obviously, as we learn more, we will update you, but if you've got any particular queries, then please do get in touch with us. So that's all from us for now. Make sure you've signed up for updates and follow us on social media, where we post all of the hot goss on property litigation stuff.
That may be overstating it somewhat.